Your Honors, may it please the court, my name is Ramad Perry, and I represent 2-1 in this action. I'll be arguing that the conduct of Mr. Boyd did in fact constitute bullying under California law. Before I get into the statute, I'll read you the case itself. 10-1 was one of the 14 students out of 700 who just transferred to Charlie White's middle school. The obvious target of bullying because 10-1 was an obvious minority because of his Asian descent in a mostly outnumbered school and the smallest of all the Asians.
Counsel, we're very familiar with the facts of the case. How about, can you tell me what the court should look to when we're trying to decide where to draw the line between teasing and bullying under the statute?
You should look to where teasing doesn't usually go on as a long period of time. Teasing, it may be one time in the hallway, but this was a campaign against 10-1 that E-Boy made out with many of his friends to persecute 10-1 for no other reason than just to do it. E-Boy persecuted him when he called him Einstein and later referred to him as the King of Einsteins by using a poster he made and posted it all across the school. E-Boy also used one of his friends to create a fake Facebook post referring to King 10-1 as the author, referring to him as the King of Einsteins, and he had total mastery of all the mathematics, although 10-1 was actually doing poorly in his math.
But there was no obscenities or vulgarities. Why should we look at that as bullying versus teasing?
Because this, as in California Education Code section 48,000 subsection 1B, this caused a reasonable people to experience a substantially detrimental effect on his or her physical or mental health because 10-1 tried to commit suicide because of all this bullying.
Before you even get to that, doesn't it have to be severe or pervasive?
It was severe and pervasive because it kept going over a long period of time, and he used electronic means to do this by sending text messages to other students calling him King of Einstein to Einstein.
By saying it went over a long period of time, you seem to be saying it was pervasive, right?
Yes.
So how many times amounts to pervasive?
I'd say over twice.
Do we find that number anywhere in the statute?
No.
Does it matter that some of the conduct occurred off of campus?
Yes, it mattered because
Can the conduct still qualify as bullying
yes,
even though it occurred
because
elsewhere?
it came back to the school and disrupt the learning environment. If kids are going around while they should be in class sending text messages calling 10-1 Einstein, it's definitely disrupting the school's mission to educate them all. And in Code 234, the school has a duty to protect all students against things such as bullying.
The drawing wasn't an actual picture of 10-1, so why should we conclude, what are the reasons why we should conclude that it was directed at 10-1 and not one of the other 13 other Asian students?
Because the drawing was of a parent Asian male with equal signs with a picture of Einstein, and if you boys calling only 10-1 Einstein, it's pretty obvious that he's referring to 10-1 in his poster. Also, in California Evidence Code, section 48,900, subsection 1C, which states causing a reasonable people to experience substantial interference with his or her academic performance. 10-1, before he tried to commit suicide, started missing school, which definitely affected his academic performance in a negative way.
Court. My name is Bianca Almanza, and I represent 2-1 in this action. I will be arguing that the communications by Mr. Boy and his friends directed towards 2-1 were most definitely not protected by the First Amendment of the Constitution. Any discussion of the First Amendment must start with Evidence Code 32261, the basic educational mission to provide a safe and secure and peaceful environment for students. Mr. Roy went against this basic mission. He in fact bullied 2-1 on and off campus. It is the school's district's duty to protect each student and to have a peaceful environment. According to the Kowalski case, it was foreseeable in this case that Kowalski's conduct would reach school via computers, smartphones, and other electronic devices. And this is exactly what happened to 2-1 when the Facebook page was created to mock them.
Counsel, why shouldn't we look at this case as being more like the late shot case, where the court found that suspending the student over a Facebook page or MySpace page was a violation of his First Amendment rights?
Because 2-1, because it was foreseeable that the actions on the computer, the Facebook page of 2-1 would follow him to school because of the smartphones that people have nowadays and other electronic devices. And also with the posters put up around the school, it did follow him to school. And also, for 2-1, the rights of students in public schools are not always the same as the rights of adults in other settings. The school does not have to tolerate student speech that is inconsistent with its basic educational mission to educate students and provide a safe environment.
But don't the students have rights under the U.S. Supreme Court's Tinker versus Des Moines decision? It says that students' First Amendment rights don't stop at the schoolhouse door. They still have the right to speak.
Yes, but to some extent. When Hugh Boy created a campaign, as my other council member stated, it followed him to school and disrupted the environment, so that was crossing the line, basically.
Well, this may be a better question for the next person to speak, but how is a school supposed to monitor everything the students say outside of school hours on Facebook, on text messages to each other? That's putting a big burden on the school, isn't it?
Yes, but it's the school's responsibility to monitor these actions. The school can say cell phones aren't allowed outside during school hours to stop the distraction, but that's not what happened. It wasn't stopped.
But didn't the trial court here say that there was a policy that complied with the education code that dealt with bullying here?
Yes, but it wasn't exercised to enough extent to stop the bullying.
Okay.
Any more questions? Okay, first, please.
Your Honors, may it please the court, my name is Aaron Sanders and I represent Mr. 2-1 in this action. The sequestered Board of Education should be held liable for the damages dealt towards Mr. 2-1 because of Hugh Boy's and his cohorts. It is the board's and school district's responsibility to make sure that they provide a safe learning environment for their students as listed in Ed Code 234 and 234.1. In the case of Mr. 2-1, they failed at this.
Counsel, what evidence is there in the record to show that the school board knew about the alleged bullying?
Well, for one, the principal did take some, but it was a little, the principal did take very little action to handle this by removing the posters, but in that action, I suppose it was his way of basically saying if it was brought back to him, he could say, oh, I dealt with it in my own way, but that action was too little too late considering the incessant and continued harassment and Mr. Boy caused to Tin Juan that the school failed to disrupt or intercept in any way.
Was the school board the actual cause of the harm?
The principal is hired by the school district, therefore he's representative. Therefore he is a representative of the school district. So anything that falls on him does reflect on the school district. They can't just throw the principal under the bus or say it's not our problem, because then other parents can come in and say that the principal did it, and that if you bust the principal, then eventually that principal's going to go broke, and so on and so forth.
Counsel, assuming we agree with you that there should be liability, how far should that liability extend and why? I mean, is it all of the 14 Asian students? Some of them?
The liability, actually, can you rephrase the question, please?
In the facts of this case, we're dealing with the damages that Mr. Juan supposedly suffered. How far should we extend that liability? Should it go to all of the other 13 Asian students at the school? Just some of them? Only Mr. Juan? And why?
It should be extended to the other 13 students that were harassed, but considering that Tin Juan was the main target and he was the one who reported it, out of those 13 students, then in a way, yes, the liability should be spread. But since we are not talking about the other 13 students, we're talking about Mr. Tin Juan and his actions, I believe the school district is responsible for such actions that have taken place. That the school failed to basically stop, because the action that they took was basically removing the posters down all over the school. Now that may have worked in some way, but considering the fact that this is spread all over the school and it was spread faster on Facebook and text messages and all that stuff, kids were starting to remember. Because taking down posters of it isn't, if you're taking down something visual there, something physical, it will not make people forget. Because if someone came in here and filmed us in their lip, and the only evidence that they had was us and the cameras, and they said got rid of the cameras, well, that's just getting rid of the evidence for the cameras. But everybody else remembers what happened.
So, Mr. Sanders, let me give you a hypothetical. Let's say that somebody goes home and they check on their Facebook page, and one of their classmates leaves a message on their Facebook page saying, everybody at school hates you. And then they don't go to school the next day because they think everybody at school hates them. Is there any liability for the school under that situation?
Even though in the hypothetical example it did say everybody at school hates you, that action was not taken at school. But in the case of Mr. Tin Juan, actions that were taken off school campus were then brought to the school campus, and then it immediately became their problem. But in your hypothetical example that happened off campus, and that could be if the child decided to bring it towards the principal, then yes, then it is then the school's problem. But since it was not brought to their attention in hypothetical, it possibly or maybe not be the school's.
I understand the second point, since it wasn't brought to their attention, but you seem to say that since it happened off campus, that the school had no liability. If that's the case, how do you deal with Kowalski, where she made all those comments about her classmate off campus, and the school suspended her, and the court said that was fine because what she did caused problems at school?
Well, because then the actions that happened off campus affected everybody else at school, and that disrupted the learning environment. That was brought back to school, I should say. So therefore, that it is school's problem. It was brought forth to them, and it was brought to their attention. Because if I'm in my class working and there's one kid talking to himself, if it's not disrupting me, then it turns out not to be my problem. And then it starts disrupting me and other classmates, then it becomes an issue.
What do we do with the fact that it seemed like there were other classmates at Tin Juan that were also called Einstein? That he seemed to react especially bad to that. Why should he be awarded damages just because he was very sensitive to being called what some people might think is a compliment?
In that case, if someone kept on calling me tall every day, then that would be a compliment. But the minute they start calling me, man, you're tall, how's the weather up there? Starts going on and on, becomes sarcastic. Then that becomes offensive to me. And it's no longer a compliment. It is turned into a sarcastic remark that is happened. That's supposed to be the negative view about me. Because in that point, because there's a certain point where a compliment turns into an insult. There's a line there that happens to me, and you boys crossed that very quickly when he started calling Mr. Tim on the King of Einstein. So in that sense, it started as a compliment for a very, very brief moment in time, and then quickly turned into an insult that added to the list of factors of Mr. Tim on suicide attempt in that case. The compliment became very negative. He didn't like it, and then there's pictures brought all over it. Brought all over the school, and that just to him it became apparent very quickly that it was no longer a compliment. It was a tactic in trying to tease and humiliate him.
But how does the court, what kinds of things should the court look to when we're trying to decide whether a plaintiff is just overly sensitive versus a reasonable person would not have been offended?
Tim Wan was not sensitive to begin with. I mean, if it was just the teasing, then yeah, he could possibly be viewed as an overly sensitive person. But considering the factors that went into his attempted suicide, the fact that his grades were very low, and also the fact that his grades were low also brought to the attention of the principal in various meetings, and also the fact that since Mr. Tim Wan is brought up in a somewhat traditional Asian family. Stuff. If you do something bad in the Asian community family, it's viewed as being dishonor to your family. So in that sense, that also brought him down low. He was close to the edge, and then the bullying pushed him over the edge to make him attempt suicide. The bullying was the final nail in the coffin for him. He couldn't take it anymore. It was continued, incessant, and it just kept going. And to him, he thought the school would help him. Because the school, in a way, people go to school, because if everybody left school because of teasing, then there wouldn't be a lot of kids in school. People stay there because they know that the principals, the teachers, and sometimes even the other faculty and staff have their back because bullying is not allowed, and I think it is a crime in some areas. But because of that system that stands right behind you to make sure that you are taken care of, but for this to continue going on, he looks at schools and they barely do anything. Well, that just also pushed him over the edge. So in this case, the school district should be held financially liable for this, for Mr. Dubois' bullying. Not only that, but since Mr. Tim Wan's demographic being the minority, the school itself should have taken notice to that potential risk factor. The risk of Mr. Dubois' actions and effects should have been foreseen considering all the above listed factors I have stated. For all these reasons, I ask the court to rule in favor of the appellant.
Response now?
Mr. Chief Justice, and may it please the court, my name is Arthur Cooper, and I am here to demonstrate that Hugh Boy's teasing of the appellant Tim Wan does not constitute bullying under California state law, on the basis that Hugh Boy was not severe in his actions, and that Tim Wan is not a reasonable pupil. My co-counsel Janice Kuhn will demonstrate that Hugh Boy's speech is protected under the First Amendment. My co-counsel Andie Romero will demonstrate that the Sequester School District should not be held financially liable, and my final co-counsel Edward Rickford will rebut the appellant's arguments. According to section 48900, subsection 1 of the California Educational Statute, bullying is defined as any severe or pervasive physical or verbal act or conduct. My first point is that Hugh Boy was not severe in his conduct. According to Webster's College Dictionary, To be severe is to be of an extreme, intense, or violent character. In no way was Hugh Boy violent in his teasing of Tin Wan. In no way was Hugh Boy extreme in comparing Tin Wan to Einstein. And in no way was Hugh Boy particularly intense in asking a friend to embarrass Tin Wan via Facebook.
Counsel, is the language from the dictionary definition incorporated into the statute?
No, it is not, Your Honor.
Is the word violent anywhere found in the statute?
No, but to be severe could be to be violent.
The text of the statute is severe or pervasive, correct?
Yes, Your Honor.
Can you give me an explanation of why you think that the conduct that's in the record is not pervasive?
Because while to be pervasive could be defined as to be omnipresent, and Hugh Boy's behavior is hardly omnipresent. While it does pervade several areas of Tin Wan's life, it is not the duty of the school to consider the off-campus behavior of Hugh Boy, because, as my co-counsel will demonstrate, that behavior did not cause a substantial disruption on campus and was not brought back to campus and is therefore not.
How can you say that? I mean, he almost committed suicide and he dropped out of school. If he's not going to school, isn't that affecting his ability to get an education? And that is causing disruption on the campus. Well, it certainly is for him if he's staying home.
Yes, Your Honor, that is true. However, it was entirely Tin Wan's choice, his own willing choice, not as a reasonable pupil, but as himself to skip school as a consequence of this relatively minor action by Hugh Boy.
How many times does somebody have to tease somebody before it becomes pervasive?
Your Honor, I don't know if I could set a specific number, but to be pervasive.
Well, you're saying that what happened to Tin Wan was not pervasive. So walk me through your analysis of that. Why was it not pervasive? Is it the number of times? What is it?
It is both the severity and the fact that it was not all-encompassing. Hugh Boy did not invade, if we were to consider off-campus conduct. Hugh Boy did not invade Tin Wan's home. He did not, Tin Wan was completely in his own private home, untouched by this conduct, which disqualifies it, in my mind, from being pervasive.
Then how do you distinguish the Kowalski case? This was the one before about the student who sent all these messages to her classmate, calling her, or started a page about her classmate, calling her things like a slut and things like that. And she was punished for that, and that was completely off campus. So how do you distinguish that kind of situation?
Could you rephrase your question here? Sorry.
You're familiar with the Kowalski case?
Yes.
So this is the one where she created the page about her classmate, and she called her all these disgusting names, right? And she got punished for it, didn't she?
Yeah, she did.
So why can you punish that student, but you're saying that what happened to Tin Wan was all off campus, so there's no liability here? Why the distinction?
Because of the severity of, Your Honor, because of the severity of that conduct, as opposed to the mild severity, or not even severity at all, of Hugh Boy's conduct. While calling someone a slut is far different from calling someone Einstein, which could be easily.
Well, like Mr. Sanders said, you're on the other side. He said that some people, they wouldn't mind saying like, hey, wow, you're really tall. Or some people would love to be called skinny. But if you call somebody skinny every day for a month, some people are not going to like that. So why do you want to create a situation where you encourage people to call each other names whether they like it or not? What I'm basically saying is, doesn't the student, they take their own chance? If you call somebody a name, whether it's skinny and you think it's a compliment, and they don't like it, well, you've taken your chance, and if they react badly, that's on you. You shouldn't be calling people names.
But we have to decide what a reasonable pupil's reaction would be to that conduct. If a reasonable pupil were to react to the being called a slut or being constantly harassed on Facebook in a very severe fashion, that would be reasonable. that would be understandable. However, a reasonable people would not react in such an extreme way as Tin Wan did to merely being called Einstein. It's all about whether or not that pupil is reasonable or not.
But counsel, the picture that was also posted is very offensive in my mind. Convince me why the court should not see that that is something severe. It's one thing to use words against a classmate, but the picture was rather offensive in a racial type of way. So convince me why we should not see that as something severe.
The cartoonish drawing that compared an Asian male to Einstein, while it could be taken as being very offensive, even racist, is not of the same severity as blatantly calling someone, as your fellow justice stated, a slut. Just the extremity, comparing an Asian male to Einstein and saying that they're both smart almost is not the same as assaulting someone's sexuality. It's not, one is just far more severe than the other, Your Honor. Another requirement of the California Educational Statute is to be considered bullying. Conduct must cause a reasonable pupil to be in fear of harm. In no way was Hugh Boy's conduct ever to put Tin Wan in fear of harm. His actions were in no way violent, and nor did they hint at any violence.
But under the statute, isn't it has to be one of the four categories? I'm reading, has to have the effect of one or more of the following, and fear of harm is only one of the four. So even if you knock that one out, there's still three other possibilities, right?
Yes, Your Honor. The other three possibilities are negative effects on academic performance or physical, or detrimental effects on academic performance, physical or mental health, or ability to participate in or benefit from school services. However, Tin Wan was an unreasonable pupil. In response to being called Einstein, his extreme reaction constitutes being an unreasonable pupil, as a matter of fact, which in a way disqualifies him from the remaining stipulations of the statute. However, and with the evidence provided, I urge the court to rule in favor of the respondent.
Mr. Chief Justice, and may it please the court, my name is Janice Poon, and I'm here to urge the court to find Hugh Boy's speech protected by the First Amendment and thus falls out of the school district's bounds of discipline. Freedom of speech is a cherished constitutional right, with the First Amendment guaranteeing free speech and expression, and only in extreme and limited circumstances can it be restricted, such as in incitement, obscenity, and threats.
But that's not true in the school setting, is it? That students, they have much more limited free First Amendment rights than do people publishing a newspaper.
Your Honor, when you look at our facts, Hugh Boy's speech does not fall into those circumstances, whether he is on campus or off campus. Even when we look at the Tinker Standard or the Hazelwood case, Hugh Boy's speech could not be censored because, one, his remarks were made off campus, two, his remarks are far from lewd, threatening, or vulgar, and three, his actions cause no substantial disruption on the school environment.
Counsel, didn't Mr. Boy post pictures on campus of a caricature of an Asian male with Einstein and the equal sign?
Your Honor, Hugh Boy did post caricatures of Hugh Boy, but the facts do not show whether it was on or off campus. And even if it was on campus, which we presume it was, the school took all the action it could. The school did take the necessary action by removing the poster, but that was all the action it could take because the rest of the speech was protected and they did not censor the other bullying, which is online, or the verbal bullying.
So, counsel, are you arguing that the school principal could not have imposed any level of discipline against Hugh Boy? And if so, why do you make that assertion?
Well, Your Honor, the principal took all the action he could by censoring the speech which was unprotected, which was the speech that was made on campus with the posters, which could create disruption, but the rest of the speech was protected and the school could not censor it. Hugh Boy made some mean spiritual remarks towards Tin Juan with some juvenile teasing about him being the king of the Einsteins. And Boy also later sent a text message around and created a Facebook page joking about as Boy mistakenly believed Tin Juan's mathematical talent as the king of the Einsteins. But all these events occurred off campus. And this aligns with the Lakeshot case, where school officials cannot discipline such alleged misconduct if it did not even occur on school grounds. And the speech cannot be regulated as it simply didn't occur in the school context.
But didn't it have an effect in school?
Well, Your Honor, when we look at our case, there was no substantial disruption occurring at the school as established by Tinker, which the courts held that the speech must materially and substantially affect the school environment. When we compare our case to Lakeshot accessed the Facebook page from school, and that led to disciplinary action of 20 students, as well as disruption in class. If the court ruled that in Lakeshot that there was not enough substantial disruption to censor the speech, and in our case there is much less of that, no widespread disorder occurred, no classes were canceled, and thus speech is protected.
But isn't part of the difference there that it's not really a fair fight? I mean, if you say something about your principal or your teacher, they have a way of disciplining you, and they can make you stop it. But if you go and say something about a fellow peer, they have to go to somebody in authority to make them stop it. So Lakeshot, he was the principal, and he could do something about it, but Tin Juan couldn't do anything about it unless the school acted, right?
Your Honor, it really depends on the severity of the speech and how much substantial disruption it can cause. When you accuse a principal of being a pedophile, that led to a deterioration of student discipline and eventual questioning of the principal's character, which of course can profoundly affect the school environment.
He said a lot of bad things about him in Lakeshot. Did he accuse him of being a pedophile?
Oh, sorry, that's a Snyder case. But in Lakeshot, he did make very vulgar accusations of him doing drugs, alcohol, and being a sex addict, which is very pervasive and is much more severe than in our case. And such as established in the Tinker case, it doesn't interfere with the operation of the school, which distinguishes our case from the Kowalski and Snyder cases, where students' inflammatory harassment of another included much more severe and lewd accusations of sexually transmitted diseases and pedophilia, which of course would lead to a substantial disruption of the school environment. And
Counsel, here the pictures were posted, presumably on campus, maybe somewhere off campus, in the Facebook page. I think we could assume that Mr. Hugh Boy did that knowing that other classmates would see that. So why shouldn't we see that as something that's going to result in disruption to the school environment?
Well, Your Honor, when we look at the content of the speech, its content is simply not as inflammatory as in Kowalski. Saying another student is the king of the Einsteins is some minor teasing, but it can't lead to a severe disruption in the school environment. And because his speech was made, failed to create a major disruption in the school environment, I urge the court to see that the school has no authority to abridge Hugh Boy's free speech rights under the First Amendment. And now my co-counsel will discuss the issue of negligence.
Mr. Chief Justice, and may it please the court, my name is Andie Romero, and I'm going to demonstrate that Sequester School District should not be held financially liable for the appellant's damages. I will demonstrate first that Principal Thick did not owe a duty of care to Tin Juan, and second, that the appellant failed to prove causal linkage or rise to the level of healthy skepticism that the court should allow, and did not prove linkage between the Sequester School District's supposed negligence and his damages. The element of foreseeability established in Paul's graph and Dillon state that liability of tort stems directly from sufficient foreseeability of risk.
But counsel, what made it foreseeable for the principal to realize that Tin Juan was going to attempt suicide and have all these other bad effects?
Your Honor, there was nothing in the facts or anything in the facts that a reasonable person in Mr. Thick's shoes would find that a reasonable pupil would react in such a way. as Your Honor has stated, has mentioned that he committed suicide and whether that was for foreseeable consequence. Your Honor, attempted suicide or even emotional distress is a completely unforeseeable consequence. If we look at the standard and the precedent set in Paul's graph, where there was a box or a package that contained explosives, the court found that it was not an apparent zone of danger, and there was nothing that would give reason for a reasonable person to suspect that it would explode. And if we relate that standard to our case, there's nothing that a reasonable person would foresee that he would figuratively or emotionally explode, that he would react in such a way.
But if Tim Wan told the principal that he's being bullied, why wouldn't that put the principal on notice? That the
Your Honor,
foreseeable consequence would be some damage to Tim Wan.
Your Honor, while Tin Wan did come to Mr. Thick, the facts are actually ambiguous whether Mr. Thick went to Tin Wan or Tin Wan went to Mr. Thick. But regardless, Mr. Thick did as much as he could without infringing on Hugh Boyd's protected right to free speech. He did comply with the policy by having these two meetings, by investigating as the policy holds, and he still was concerned for a student, took down what he could, what was on the school campus, and could not do anything further. Additionally, if we look at the Dillon standard, where the court found that it was foreseeable, that the driver would find that the negligent driver would foresee that hitting or the impact of hitting a young child, that young child's mother would be in that zone of danger or would be in that very proximity. It's very different in the case before us because there was, again, no foreseeability that such action would cause a person to act in this way or have emotional trauma or distress.
Counsel, isn't it true that the principal met not once but at least twice with Mr. Wan and learned about the effects of the bullying on him?
Yes, Your Honor. He was a very knowledgeable principal. He met twice. He was very knowledgeable about not only the alleged bullying, but of the stress, the other factors that could contribute to his supposed emotional distress.
What are those other factors?
His parents' pressure, his failing grades, and just the pressures of being one of the 14 Asian students in his school. Your Honor, as our opposing counsels have conceded and even acknowledged, was the facts that he was pressured, and as I have mentioned, the other factors, then it's more like Stolzen in causation, in regards of causation, where it was ambiguous whether that one factor would, the negligence would be the proximate causation of his emotional distress, or in Stolzen's case, that the government's negligence was the proximate causation of her hypochondria symptoms. If we look at the Stolzen standard, it held that there needs to be, the court must hold healthy skepticism, and it does not need to rise to a clear and convincing evidence. But either way, it is our case before us, and the facts that, the glaring facts in our case show that it does not rise to clear and convincing evidence or a healthy skepticism, which this court should allow.
Mr. Romero, don't you have to deal with the fact the trial court said that the anti-bullying policy the school had did comply with the education code, but the principal didn't follow it?
Your Honor, if you look at the statute holds that the school district should have a policy that has a way of investigating, but this California statute does not clearly dictate it does not clearly dictate a duty. The only way that we can find that there's, I see I'm out of time, I know this one.
Rebuttal from the appellant.
May it please the court, my name is John Lee, and I will be arguing for Tin Wan in this rebuttal. Tin Wan was a reasonable pupil. Tin Wan attempted suicide, but under this amount of bullying and pressure, any normal student would begin missing school and even commit suicide. Mr. Wan also receives off-campus tutoring, but any normal person can also receive tutoring. It was foreseeable that Tin One would attempt to commit suicide. Because under this amount of bullying, any normal person would try and commit suicide. And along with the pressure of his failing grades, it is foreseeable that it will lead to suicide.
The council, the opposing council characterized this as more just mere teasing. Why should we not agree with that?
Oh, this is absolutely not mere teasing because in this case, Mr. Boy went to extreme lengths to degrade and insult Mr. Wan. For example, he spent his time making those drawings of comparing Mr. Wan to Einstein. He even had his friend commit a fake Facebook page claiming Mr. Wan had total mastery of all mathematics subjects. Those are some pretty extreme lengths to go to to compliment someone. And this did cause a reasonable disruption on the school campus and the school environment. And so much so that, in fact, the posters had to be removed because it caused so much of a disruption.
Counsel, weren't there other pressures in Mr. Wan's life that could have led to a suicide attempt? Your opponents have pointed out a few things like parental pressure and pressure of being one of a few Asian students at the school. Should we discount those as being factors in his decisions to try to commit suicide?
Well, those could definitely be factors, but in Mr. Wan's case, it could. And the remarks were made off campus, but under the evidence code section 32261, the school must provide a safe and secure, peaceful environment for students. This was disrupted. This disrupted the school's environment. For example, posters had to be removed. Once again.
But were any other students affected by the posters and you boys' actions?
Well, no of the students were affected directly, but the students were. It did disrupt the environment because the students began picking up on this and calling Mr. Wan king of Einstein, which could have definitely caused a disruption.
Mr. Lee, what is your response to the other side argued that the principal did everything he could by tearing down the posters and everything else that was said was protected speech? Do you agree with that argument or disagree?
No, I disagree.
Okay, and why is that, and what is your reason?
The principal could have definitely done more to protect Mr. Wan. For example, he could have stopped it immediately, and he could have had the Facebook page suspended, or could have definitely done more. Any questions? That's my case.
Honorable Chief Justice, and may it please the court, my name is Edward Bickford, and I'm here to show the weaknesses in the appellant's argument that were especially notable in their interpretations of the anti-bullying statute, Kowalski versus Berkeley High School School District, and Layshaw. The appellant argued that Mr. Wong was the subject of severe bullying perpetrated by Hugh Boyd, but the evidence shows otherwise. The worst Hugh Boyd ever did was equate Tin Wan with Einstein, one of the most respected men of the 20th century. This hardly seems like bullying. The appellant claims that this was said derisively since Mr. Wong was failing his math class, but failed to mention that Hugh Boyd was not even aware of this. It is more than probable to believe that Mr. Boyd truly did believe that Mr. Wong was a bright and gifted student. Furthermore, there is no cause of action in the anti-bullying statute. Even if the school is to be found guilty of failing to uphold the statute, nowhere does the statute give others the power to make the school financially liable for doing so. The appellant believes that the ruling of the court's inequality should carry over into this case, but there are just too many differences between these cases to do so. In the Kowalski case, another student was accused of having an SD and other extremely inappropriate things. The speech in this case never once rose to such a level. Hugh Boyd's speech was not lewd, nor was it suggested. And to apply the same standard in Kowalski to Hugh Boyd's speech when it was none of these seems hardly fair.
Counsel, wasn't the conduct pervasive? Wasn't it a constant onslaught of teasing and posters and Facebook pages?
Your Honor, even if that were to be true, teasing is considered free speech. It is bullying that is not considered free speech. The appellant argued that Hugh Boyd's speech was disruptive, but let us not forgetting the ruling of the courts in the Layshaw case. In the Layshaw case, 20 students were called out of class because of one student's speech. The principal said that there was a culture of disobedience after this one student's speech, and yet the courts found that this speech was not disruptive. This speech seems much more disruptive than anything Hugh Boyd ever said. And to say that Hugh Boyd's speech was disruptive when speech in Layshaw was not seems hardly fair.
So why would we want to create a rule that gives more protection for students teasing and calling each other names? Isn't it better to have a rule that says that you shouldn't be doing that when you're in school and you take your own chances if you do that, and the person reacts poorly?
Your Honor, if the anti-bullying statute is to be reformed, it must begin at a legislative level and not the judicial level. The appellant suggests that Mr. Wan's ethnic background played a part in his suicide attempt, but this argument is based on sweeping generalizations. The appellant assumed that just because Mr. Wan was Asian, he placed a greater emphasis on education and that he brought shame upon his family by failing his math class. Such stereotyping helps nobody. The appellant believes that Hugh Boyd's speech caused Mr. Wan's suicide attempt, but there are just too many extraneous factors to believe this.
Counsel, why was it not foreseeable to the school district or the principal that Mr. Wan would react like that?
Your Honor, the principal did not have a background in psychology or medicine, and it would seem a stretch for the principal to conclude that Mr. Wan was going to commit suicide without having a background in any of these such things that would give him the foresight necessary to predict Mr. Wan's suicide attempt.
Counsel, isn't he a trained school professional who deals with students on a daily basis? And shouldn't he have be charged with some kind of special knowledge just based on his experience and his role in the school?
Your Honor, please.
Well, he's the principal of a school, and he comes in contact with students every day. Shouldn't he be charged with some kind of special knowledge about whether a student is in crisis and get the student the help he or she needs?
Your Honor, it is true that a principal should be familiar with the way students operate and the way they are, but that is not to say that Tin Wan was just like every other student. And it's questionable whether or not he even meets a standard for a reasonable student. The school has been accused by the appellant of failing to uphold the law, but freedom of speech is a legally protected right. If the school had taken action to censor Hugh Boyd's speech, then they wouldn't have been violating the Constitution. Your Honor, I see that my time is up.
Thank you very much for your presentation. We will now confer amongst ourselves for a few moments, so if you could please wait out in the hallway. We will